Hello everyone, I am Dr. Aparajita Bhatt from National Law University, Delhi. The topic for this module is Compromise, Arrangement, Reconstruction, Mergers and Amalgamations of Companies in India. You shall be able to understand about the concept of corporate restructuring, merger and amalgamation. Other learning objectives are that you shall also be able to understand about the legal provisions related to mergers and amalgamations under the Companies Act 2013, and you shall also be able to understand about the role of judiciary or National Company Law Tribunal in sanctioning the scheme of merger or amalgamation. We shall discuss under this module the meaning of corporate restructuring, the need of corporate restructuring, various forms of corporate restructuring, and the legal issues pertaining to mergers and amalgamations in India. Now, before we proceed, we must understand and discuss the meaning of corporate restructuring as to what is meant by this term. Corporate restructuring is a general term used for various kinds of business transactions which are required for the growth of a company. Such business transactions are governed by different regulations in different jurisdictions. Now, what is the need for corporate restructuring? We must understand this. Companies restructure themselves, or they have to mandatorily restructure themselves for two basic purposes. The first one is the survival, for the purpose of basic sustenance in the market, in the industry, and the second important reason is growth. There are various forms of corporate restructuring which are prevalent in the corporate sector. One such form is organic, or which is also known as internal restructuring. Organic restructuring is done within the organ of the company, within the system of the company. It can be divided into following categories: operational restructuring, financial restructuring, managerial restructuring. Now, all these three kinds of restructuring are done within the organ of the company, and therefore they are known as organic restructuring or internal restructuring. Another kind of restructuring is inorganic or external restructuring. They can be divided into, say, mergers, amalgamations, acquisitions. All these are forms of inorganic or external restructuring because an external company or an external element is involved into the entire process of restructuring. There are various other common forms of corporate restructuring exercises, and they include expansion. In case of expansion, the most common forms of expansion are mergers, amalgamation, tender offers and joint ventures. Another category is sell-offs, which includes spin-offs, split-off, split-ups, divestitures and equity carve-outs. Another kind of corporate restructuring activity is corporate control, which includes exercises such as premium buybacks, standstill agreements, anti-takeover amendments, proxy contest, etc. And the last category can be the changes in ownership structure, which includes share repurchase, various exchange offers, and going private such as LBOs and MBOs, that is leveraged buyout and management buyout. Now, there are many reasons why companies should restructure themselves, which we will discuss under this topic, that is reasons for corporate restructuring. The most common reason are, for example, such as economies of scale, synergy. So, therefore, we can divide these reasons into following categories. One can be the companies wish to concentrate on area of core competency or area of their specialization. Another can be to achieve economies of scale by expansion. Companies also restructure themselves for geographical and product diversification. They also wish to achieve operational synergy and efficient allocation of managerial capabilities. Another important reason for corporate restructuring is the revival and rehabilitation of sick companies. Vertical integration, it enables acquiring constant supply of raw material and access to scientific research and technical know-how. And companies also restructure themselves to improve corporate performance and bring it at par with their competitors. Now, let us discuss and understand the meaning of each one of these forms of corporate restructuring exercises very briefly. The first one is merger. What is a merger? Merger is the combination of two or more companies into a single company where one survives and the other loses its identity. Now, in case of a merger, all the assets, all the liabilities and all the shareholders are transferred by the transferor company to the transferee company. And the consideration in such a case is in the form of equity shares, debentures, or a combination of 2 or 3 modes. So, mergers are different from amalgamations. In case of merger, there are two companies A and B. So, when they merge, either A would survive or B would survive, whichever is the stronger company, whichever is the healthy company. But in case of amalgamation, when both the companies so amalgamate or blend into each other to form a third new entity, that is A plus B is equals to C, then that is a case of amalgamation. So, what exactly is an amalgamation? An amalgamation is the blending of two or more companies, existing undertakings, into one undertaking. The shareholders of each blending company, they become the shareholders of the company which is the blended one, which is the new entity. And the assets and liabilities of both the companies are transferred to the newly formed entity. Mergers and acquisitions together, they refer to the aspect of corporate strategy or corporate finance and management dealing with the buying, selling, dividing and combining of different companies into one, and different companies and the similar entities, so that they can help an enterprise grow rapidly in the sector or location of origin. Now, what is a tender offer? This is again a kind of corporate restructuring activity. In case of a tender offer, one party, which is generally a corporation seeking a controlling interest in another corporation, asks the stockholders of the firm which it is seeking to control to submit or tender their shares of stocks in the firm. In such a case, the offer is to purchase some or all of shareholders' shares in a corporation. The price offered in tender offer is usually at a premium to the market price, and it can be either friendly or unfriendly. What are joint ventures? Joint ventures are intersection of only a small fraction of the activities of the companies involved. It is done for a limited duration of 10 to 15 years or even less. The companies may represent a separate entity in which each of the parties makes cash and other forms of investments. It is a business agreement in which parties agree to develop for a finite period and the new entity and new assets by contributing equity. In case of a joint venture, the companies, they exercise control over the enterprise and share revenues, they share expenses and they also share assets, and because of this sharing nature, they are known as joint ventures. They are together for a particular venture for a definite period of time, and once the venture is over, they go back to their same places. They are not merged, they are not amalgamated, or they are not blended as in case of a merger or amalgamation. Sell-off is another kind of corporate restructuring exercise. The rapid selling of securities such as stocks, bonds and commodities is done in case of a sell-off. The increase in supply leads to a decline in the value of the security, and this rapid sale of security by a large number of holders increases the supply of security available for sale, and therefore it drives down the price. Split off is another variant of demerger, which is again a kind of corporate restructuring exercise. In case of a split off, a portion of the existing shareholders, they receive stock in a subsidiary in exchange for parent company stock. Whereas in case of a split up, the entire firm is broken up into a series of spin-offs, so that the parent no longer exists and only the new offsprings survive. Divestiture is another variant of demerger. It involves the sale of a portion of the firm to an outside third party, and in this case cash or equivalent consideration is received by the divesting firm. The buyer is an existing firm, so that no new legal entity results in case of a divestiture, and it simply represents a form of expansion on the part of the buying firm. Similarly, equity carve-out is another variant. It is the initial public offering, that is IPO, of some portion of the common stock of a wholly owned subsidiary. They are also referred as the split of IPOs. It involves the sale of a portion of the firm via an equity offering to outsiders. New shares of equity, they are sold to outsiders, which give them ownership of a portion of the previously existing firm, and in this case a new legal entity is created. Similarly, premium buybacks are another form of corporate restructuring exercise, wherein the repurchase of a substantial stockholder's ownership interest at a premium above the market price is done. A standstill agreement is written, and it represents a voluntary contract in which the stockholder simply agrees not to increase his or her ownership beyond the ownership which is there in the hands of the management, which presumably would put him or her in an effective control position. Anti-takeover amendments, they are changes in the corporate bylaws to make an acquisition of the company more difficult or more expensive. Similarly, proxy contest, in this case an outside group seeks to obtain representation on the firm's board of directors. Dissidents or insurgents who seek to reduce the control position of the incumbents or existing board of directors, and therefore, in this case usually it is regarded as directed against the existing management of the company. This is the proxy contest. Changes in ownership structure, in such a case the exchange offers, wherein the exchange of debt or preferred stock for common stock is done. And in case of share repurchase, the corporation buys back some fraction of its outstanding shares of common stock. Another form is going private transaction, which includes activities such as LBOs, that is leveraged buyout, and MBOs, that is management buyouts. Going private transactions typically include members of the incumbent management group who obtain a substantial proportion of the equity ownership of the newly private company. When the transaction is initiated by the incumbent management, it is referred to as management buyout. And in case of a leverage buyout, a type of aggressive business practice whereby the investors or a larger corporation utilizes borrowed funds or debt to finance its acquisition. Now, integration or merger can further be divided into vertical merger, horizontal merger, or conglomerate merger. In case of an horizontal merger, two firms which operate in the same kind of business activity, they merge with each other. The main purpose of this kind of merger is to obtain economies of scale, to reduce the investment in operations and broadening the product line, reduction in investment in working capital, elimination of competition concentration, in product reduction of advertising cost, and increase in market area. And an example of horizontal merger can be a merger between two steel firms, would be a case of horizontal merger. Similarly, in case of a vertical merger, vertical integration, it is done to expand espousing backward integration to assimilate the sources of supply and forward integration towards market outlets. In case of a vertical integration, the acquiring company through merger of another unit attempts on reduction of inventories and it implements its production plans as per objectives and economizes on working capital investment. In a vertical combination, the merging undertaking would be either a supplier or a buyer using its product as intermediary material for its final production. And in case of a conglomerate merger, this is a merger between two unrelated business firms. So, the basic purpose of conglomerate amalgamations remains utilization of financial resources and enlarged debt capacity through reorganizing their financial structure. It also enhances the overall activity of the acquirer company and creates balance in company's total portfolio of diverse products and production processes. Demerger is another form of corporate restructuring exercise in which a case the corporate splits or divides the company. It is a division of the company. It signifies a movement in the company just opposite to merger, just opposite to combination. This particular kind of restructuring exercise is common in developed nations such as UK and USA, and also in developing nations like India. We find many examples of demergers taking place in Indian corporate sector. A common example is when Reliance Industries Limited demerged into various other undertakings. Another variant is or form of corporate restructuring is reverse merger. This is also known as reverse takeovers or reverse IPOs, and it is a way for private companies to go public. It is a simpler, shorter and less expensive way to restructure itself. A conventional IPO is more complicated and expensive, as private companies, they have to hire an invest bank to underwrite and issue shares of the soon to be public companies. So, reverse merger is a good alternative to the traditional IPO route. After having discussed these various forms of corporate restructuring exercises, now let us discuss the legal provisions relating to mergers and amalgamations under the Companies Act 2013. Companies Act 2013 is a new act and it has replaced the provisions of the Companies Act 1956, but the sections related to mergers and amalgamations under the Companies Act 2013, they are still not notified and they are still not enforced. Still, the main provisions are given from section 230 onwards. The corresponding provisions were given under section 391 to 396 of the Companies Act 1956. To merge or to amalgamate is a power of the company which is conferred on the company by the Companies Act 1956 and now the Companies Act 2013. So, Companies Act 2013 section 230 makes it a power to compromise and make arrangements with creditors and members. In this case, there is an entire procedure given by the Act which the companies have to mandatorily follow. One such procedure is to come out with various disclosures. So, the company is required to disclose the following information to the tribunal. The first information is that all material facts relating to the company, such as the latest financial position, the latest auditor's report, pendency of any investigation or proceeding against the company, they have to be disclosed. Another important disclosure is that if there is any reduction of share capital of the company, if there is any, then it should be included in the compromise or arrangement. And another disclosure is that any scheme of corporate debt restructuring consented to by not less than 75% of the secured creditors in value. So, therefore, for this power to be exercised under section 230, the companies have to obtain at least 75% of the consent of secured creditors in value. Similarly, it requires and it mandates that notice of the meeting which has been convened or conducted or called upon by the tribunal and by the High Court under the Companies Act 1956, such a notice of this meeting should be individually sent to all the creditors and their classes, to all the members and their classes, and to all the debenture holders and their classes. Such notice should be placed on the website of the company. If the company is a listed company, then all these documents shall be notified to SEBI, that is Securities Exchange Board of India, and also to stock exchanges where the securities of the company is listed. The notice shall also be published in the newspaper, and the notice shall be sent to all the regulatory authorities and other sectoral regulators. It is a mandatory provision that now, for all the purposes of transparency, and to make sure that things are done in a fair and just manner, the notice should be sent to all the regulatory authorities, including SEBI, including central government, the state government, all the stock exchanges where the shares of the company are listed, the RBI, the registrar of companies, and therefore it should be sent to all sectoral regulators and all other regulators. The tribunal has to satisfy itself on various grounds before sanctioning the scheme. No scheme shall be sanctioned unless a certificate by the company's auditor has been filed with the tribunal to the effect that the accounting treatment is in conformity with the accounting standards. Now, before sanctioning the scheme, there are various grounds depending on which the tribunal would sanction the scheme. The grounds are that the scheme should be just, the scheme should be fair, it should be reasonable, it should not be against public interest, and it should not be against the interest of the minority shareholders. Now, under the Companies Act 1956, section 391 is supposed to be or was supposed to be a complete code in itself, and it was considered to be a single window clearance system. The whole purpose is to reconstitute the company without the company being required to make a number of applications under the Companies Act for various alterations which are required under the merger scheme and which may be required in the memorandum and the articles of a company. So, therefore, all such alterations are done at the stage of section 391 under the Companies Act 1956 and under section 230 under the Companies Act 2013. And this is one reason why it is known as a complete code in itself, a single window clearance system. But now there is a complete contrast from the previous act to the new act, that because consent has to be taken, representation has to be made by all the sectoral regulators, notice has to be sent to all the sectoral regulators. It is no more a single window clearance system, now it has become a multiple window clearance system. We also discussed that the scheme should not only be just and fair, but it should also appear to be reasonable. What is meant by reasonableness of a scheme? It means that the arrangement can reasonably be supposed by sensible business people to be for the benefit of the class which they represent. Now, there are various case laws to be discussed under this. One such case is Sidhpur Mills Company Limited, INRE, decided in 1980 by Gujarat court. It was held in this case that the scheme should be looked at from the viewpoint of ordinary reasonable shareholder acting in a business-like manner, taking within its comprehensions and bearing in mind all the circumstances prevailing at the time when the meeting was called upon to consider the scheme. Though the court would see whether a scheme is fair and reasonable, the initial burden in this respect would be that of the petitioner. The same ratio was followed in another case, that is in Navjeevan Mills Limited, INRE, decided in 1972. It was also held that the scheme should not contravene any law and should not be malified for a collateral purpose. The court would look into, or the National Company Law Tribunal would look into the bona fides of the proponent. It would see that whether it is in public interest and reasonable, and also in the interest of creditors of the company. Another landmark judgment in this respect is that of Hindustan Liver Employees Union versus Hindustan Liver Limited, decided in 1995 by the Supreme Court. It was held in this case that unless it is shown that there is some illegality or fraud involved in the scheme, the court cannot decline to sanction a scheme of arrangement. It was also held that where a scheme of amalgamation is sanctioned almost unanimously by the shareholders, debenture holders, secured creditors, unsecured creditors and preference shareholders of both the companies, there must exist very strong reasons for withholding sanction to such a scheme. Withholding of sanction in such a case may turn out to be disastrous for shareholders and employees and also for the economy of the country. Now, it is the discretionary power of the court or the tribunal under the Companies Act 2013 which is exercised. On the issue of discretion of the court enjoys vast powers, wide powers of discretion. Such power of discretion ranges from ordering a meeting, refusing a meeting, sanctioning a scheme, rejecting or refusing a scheme, making order to modify the scheme, as well as to wind up the companies where schemes are not workable. An important case law in this regard is Mahendra Kumar Sanghi versus Ratan Kumar Sanghi. In this case, it was held that it is obligatory upon the court to scrutinize the scheme and to see whether it conforms to the standards of reasonableness. It must also be ensured that the majority having interests of its own clashing with those of the minority whom they seek to coerce. So, therefore, the minority versus majority interest should also be checked before sanctioning or approving the scheme of merger. Another important decision was that the scheme once passed or once approved by the court or the tribunal, it becomes binding on the company, on all the creditors or members or their classes, or in case of a company being wound up, on the liquidator and the contributories of the company. It shall have the same binding effect as the order of a high court. No scheme shall be sanctioned unless a certificate by the company's auditor has been filed with the tribunal to the effect that the accounting treatment is in conformity with the accounting standards. Now, under section 231 of the Companies Act 2013, the tribunal enjoys vast power to enforce compromise and arrangement. And as we just discussed, these powers are of the nature that the tribunal can order a meeting, it can sanction a scheme, it can reject a scheme, it can modify the scheme, as well as it can make order to wind up the companies if the grounds for winding up are present there. Now, mergers and amalgamations of companies, provisions relating to this are provided under section 232. Section 232 is a facilitative provision. It facilitates mergers and amalgamations under the Companies Act. It says and states that where it is shown to the tribunal that the compromise or arrangement has been proposed for the purpose of reconstruction of the company, and under the scheme the whole or any part of the undertaking, property or liability of the transferor company is required to be transferred to the transferee company, the tribunal may order a meeting of the creditors or members or their classes. The tribunal in such a case may make the following provision: the transfer of the whole or part of the undertaking, property or liability of the transferor company to the transferee company, the allotment or appropriation by the transferee company of any shares, debentures, policies or other instruments in the company, the continuation by or against the transferee company of any legal proceeding pending by or against the transferor company on the date of the transfer, dissolution. It can also order direct dissolution of the company without winding up of any transferor company. It can also order or make provision for the transfer of the employees of the transferor company to the transferee company, and also make provisions for such incidental, consequential and supplemental matters as are deemed necessary to secure that the merger or amalgamation is fully and effectively carried out. Section 234 of the New Companies Act 2013 provides and facilitates cross-border merger. Now, this provision is a little different from the similar provision under the previous Companies Act. Whereas under the Companies Act 1956, it allowed only one-way cross-border merger. That was, any body corporate was allowed to merge with an Indian company which is incorporated under the Indian Companies Act, whereas the vice versa was not allowed. Now, under section 234, two-way cross-border mergers and amalgamations are allowed. So, now an Indian company can merge with a foreign company, and also a foreign company can merge into an Indian company. This is subject to the approval of RBI, the central bank, and that too with selected jurisdictions only. Amalgamation of companies in public interest is provided under section 237 of the New Companies Act 2013. This particular provision, it provides us with faster process of amalgamation of companies. The power in this case to order such a kind of amalgamation is vested directly into the hands of central government. It provides for redressal mechanism for the dissenting shareholders and provides that any person who is aggrieved by the assessment of compensation made by the prescribed authority within a period of 30 days may prefer an appeal to the tribunal. Another important provision under the New Companies Act is with respect to mergers and amalgamations for revival and rehabilitation of sick companies. This is given under section 261 of the New Companies Act. It provides that the company administrator may draft a scheme and provide for the amalgamation of the sick company with any other company or any other company with the sick company. So, both way merger and amalgamation is allowed. The scheme so drafted by the administrator may also provide for the takeover of a sick company by a solvent company. Now, after having discussed these important legal provisions, we also should understand and analyze as to what is the role of judiciary in sanctioning the scheme of merger. Under the Companies Act 1956, High Court enjoyed and still enjoys wide powers to sanction a scheme and approve such a scheme. The powers of the tribunal now under the 2013 Act, they include power to sanction the scheme, power to stay proceedings, power to reject or modify the scheme, and power to order winding up of the companies. Important case laws are required to be discussed here, which would help us to understand the role of judiciary in not only explaining the meaning of important terms, as well as also making us understand the entire procedure before sanctioning the scheme. One such important case is Saraswati Industrial Syndicate versus CIT Haryana, decided in 1991 by the Apex Court. It was held and the Supreme Court explained the concept of amalgamation. The court stated that in an amalgamation, two or more companies are fused into one by merger or by one taking over the other. When two companies are merged and are so joined as to form a third company, or one is absorbed into the other or blended with another, the amalgamating company loses its identity. There may be amalgamation either by transfer of two or more undertakings to an existing company. Similarly, another important case, General Radio and Appliances Limited versus M.A. Khader, decided in 1986 by the Supreme Court. It was stated in this case that after the amalgamation of two companies, the transferor company acquires a new status and it is not possible to treat the two companies as partners or jointly liable in respect of their liabilities and assets. A very important issue which arises here is that whether anyone has a right to raise objection to the scheme or not. Now, because this entire procedure of sanctioning the scheme is based on a fundamental principle of corporate democracy, it is important to give this right to raise objection or make representation to the stakeholders. Now, there is a difference on this point between the Companies Act 1956 and Companies Act 2013. Whereas under Companies Act 1956, any interested party was allowed to raise objection at any stage before the court approved the scheme. Under the Companies Act 2013, only those shareholders can raise an objection who hold at least 10% of shareholding, or only those creditors can raise objection who hold at least 5% of outstanding debt. Therefore, the new Companies Act has provided a criteria for those people, for those shareholders, stakeholders, creditors who have a right to raise objection, and now it is not that anyone can raise objection anytime. This is just to make sure that there are not many frivolous petitions or frivolous applications for the rejection of the scheme that are put up or pending before the judiciary, before the court or before the tribunal. Therefore, now we conclude. Today under this module we discussed the concept, the meaning of corporate restructuring, various forms of corporate restructuring, the need for corporate restructuring. We also discussed what are the various forms of mergers, that is vertical merger, horizontal merger, conglomerate merger. Then we discussed the legal provisions pertaining to mergers and amalgamations under the new Companies Act 2013. And finally, we also discussed few relevant, few important judgments of the Supreme Court, wherein the court explained the concept of amalgamation, explained the concept of merger, and also explained various criteria. For example, it was laid down in Mihir H. Mafatlal versus Mafatlal Industries Limited, also in the case of Hindustan Liver Employees Union Limited, that any scheme of merger should not be against minority interest, should not be against public interest, it should be just, it should be fair, it should be reasonable. Therefore, these are various criteria which the judiciary, which the tribunal has to make sure of before approving or before sanctioning a scheme of merger or amalgamation. Thank you.